proceed.
May it please the court, members of the Court of Appeals, it's an honor to appear before you today regarding a significant public health and environmental issue in the state. And I won't try to avoid editorializing or making any inappropriate comments. I realize the court's role in this matter is limited to the record. There's an initial question, as the court is aware, as to maybe this is typical of administrative proceedings, about what constitutes the record proper, because we don't have a trial or a transcript. In this case, the other side submitted an administrative record proper. We supplemented that. They then supplemented, sent a lot of the same things we sent in. But the process is a little more complicated in any event on that issue. I do want to say in opening that the issue presented before this court is significant in terms of the public health and safety and protection of the environment. The mid-waste landfill at Sandia, which is more colloquially known as a toxic waste dump, is about 5 miles southeast of the Albuquerque airport. I believe it's east of many South Valley communities. It's near the Island Westlands.
Mr. McNeil, if you listen to me, please. The court's reasonably well aware of the facts in the case. I think you're wasting time. Let's get
All right, I don't want to waste
issues in
time.
the case, okay?
All right. I assume the court has had ample time to read our briefs. This is, I think, a complex case in terms of scientific issues. There's some procedural issues that are a bit tricky. In May of 2005, the New Mexico Environment Department issued what's called a final order. That's the official title of the order. And that order unequivocally required Sandia to report every 5 years in a document that would reevaluate the feasibility of excavating the material in this mixed waste landfill, highly toxic, unlined trenches. That report would also to include analyzing the effectiveness of what had been then selected as the remedy, which turned out to be a dirt cover over the mixed waste landfill. That cover was not installed until 2009, but 5 years from 2005 to 2010, the cover was in place. The first two issues addressed in the first sentence of the operative language in Condition 5 of the final order were: 1, the feasibility of excavating this stuff from the ground, and 2, analyzing the continued effectiveness of the selected remedy. So at that point, the dirt cover had been in place for a year, so it seems to me they could have at least said, it's been there only a year, we need more time to evaluate it, but they could have certainly done what the final order dictated, which was evaluate the feasibility of excavation. There's overwhelming expert testimony in the record that excavation must occur at some point. The question is when, and the scientific opinion consensus is that the sooner the better, because of the threat and apparent existing contamination of groundwater.
Now, your position assumes that the Condition 5 required that 5-year report to be filed by 2010, correct? And every 5 years thereafter. But the condition doesn't actually say that.
I'm sorry, what?
The condition doesn't actually say that. It doesn't provide a time frame for filing these reports. Why wouldn't it be reasonable for us to interpret it to say that's vague as to what is supposed to be done, and the department then has the ability to sort of decide when it would be done. Tell me why it's absolutely clear that that 5-year time frame started when the 2005 final order was filed.
Your Honor, the order in 2005 saying every 5 years does not suggest that 5 years is going to start at some indeterminate date in the future. Every 5 years means every 5 years. If this had been an issue in 2005, should have been addressed then. This contention that this is an ambiguity in the order, we believe is bogus. It's an after-the-fact constructed rationale to defend a lack of activity on the part of the department since May of 2005. They now announce that the first report will not be due until 2019, which is 14 years after 2005.
So,
The question I have, Your Honor, is why would it be necessary to question why there needs to be a starting date in an order that says every 5 years? They've contended that we had, or somebody had an obligation to challenge this.
Well, what would be the point of, as I understand it, the report every 5 years is to reevaluate the feasibility of excavation and analyze the continued effectiveness of the remedy. So what would be the point of doing a report like that unless the remedy has been implemented? I mean, there's no continuing anything to evaluate until the remedy has been implemented.
When, Your Honor, you mean by the remedy, the selected remedy, the protective cover, the dirt cover?
I'm just reading from the 2005 order.
Okay. Point one, the dirt cover was in place in 2009. At a minimum, they should have addressed the issue of feasibility of excavation, and they could have said, the dirt cover's only been in place for a year, so we will defer a more in-depth analysis of the effectiveness of the remedy for a few years. But they didn't do anything.
Well, couldn't the 2005 order reasonably be read to start the 5-year period at some time other than the date of the 2005 order?
I don't think so, Your Honor. With all due respect, if there's an exception as to when what every 5 years means, it should have been in the order. They drafted the order. They should not be now heard to say, we didn't mean what the order says.
So came 2010 and no report was filed. Did your clients suggest that you file something with the department saying that the Sandia is in default of its obligations?
I'm sorry,
Did your client do anything when 2010 came and went and no 5-year report was filed?
I believe they did. I believe they filed numerous comments and objections to the process. But,
Did you
the
ask
government
did they ask for a hearing?
Excuse me?
Did they ask for a hearing on it? And did you give us record citations showing us where they complained about the lack of a report?
That's
It's
not
our
true.
job. It's not our job to search these big records to make cases for parties. If your client filed complaints and said to the department, they missed their 5-year time frame, what are you going to do about it? You needed to tell us about it.
I don't think it was the duty of the appellate in this case to bring before this court the department's failure to follow its own order at that point. I don't believe that
No, I
was
mean, for the purposes, even for the purposes of this appeal, if your client was complaining and noticed that the 5-year report had not been filed, was complaining to the department about it, one would think that in full disclosure, and to bolster their claim that the department is not doing what it should, they would be telling us, we've been complaining about this since the first 5-year report date was missed. Did they do that? And is there anything in the record that indicates that? And can you give me a record cite?
They didn't do that to this court because
How did they do it to the department? I'm asking whether there's any indication in the record that they did that.
Yes, there's a transcript in the record.
Where is
The
it?
problem with the record is
Can
we
you
have
give
trouble
me, can you give me a
getting
record
it.
sign? Mr. O'Neill, please. Are you hard of hearing?
Yes,
Okay, good. Well, when my jaws are moving, I'm talking, okay? So, please stop talking so you can hear what I'm asking. Do you have a record site that you could provide to me where your client complained in 2010 or 2011 about the lack of a 5-year report?
there is, Your Honor, there are citations in our briefs as to the record proper. There were documents submitted before the hearing officer and subsequent thereto objecting to the department's failure to implement and enforce its 2005 order. I don't think that was an appropriate time to file an appeal because that was not a final administrative action pursuant to 74-414 statutorily. It was a failure on the part of the department to essentially do what its own order said it could do. And there were objections raised, many objections raised. Some of these had to do with the failure of the department to comply with CFR 42-270 et al. Regulations and RCRA requirements that have to do with public notice, providing the public an opportunity to be heard, all of those things, none of which were adequately complied with. 274. Your Honor, our position is that the final order discusses each, and it uses the word each in one place, suggesting that there's not going to be one final report or evaluation report 14 years later. Every 5 years suggests every 5 years. I don't believe it requires language unless there's an exception that's needed to be stated in the final order, making the first report at the starting date of the 5 year contingent on something else happening. What happened in this case is, and at the time, by the way, that the department issued this order, it sent out press releases stressing the significance of the 5 year reporting. The hearing officer relied on that assurance in making her decision. This court, in upholding the final order, which I believe was a challenge of the protective order, and the court upheld the final order, this court of appeals, by the very language found in the opinion, relied upon the assurances provided by NMED that there would be a report every 5 years. This was a very important assurance upon which this court, the hearing officer, relied, and the department bragged about in press releases.
Well, assuming that you are correct, that the 2005 order required a report to be filed in 2010, when the October 2011 letter came out saying, no, the first 5 year report is due at such and such a time, wouldn't that have been the appropriate time for you to object and appeal?
Well, there are several details, Your Honor, about that letter that bear on the answer to your question. First, the letter written in October of 2011 was not to approve what has now been called an LGMMP, which is an acronym, obviously, for long-term maintenance and monitoring plan. Those words are found in the final order. That letter was written to approve what is called the Corrective Measures Implementation Report. It was not written to approve a long-term maintenance and monitoring plan, or LTMMP. There was an LTMMP pending at the time that letter was written. It was submitted by Sandy in 2007. It had not been acted upon, it had not been approved. The letter of October 11 did not approve that LTMMP. It was for the purpose of approving the corrective implementation plan report. There was language, if I may finish, this is important, Your Honor. That letter then included some language that upon approval of the LTMMP, the 5-year tolling will begin. First time there's any mention that the 5-year report isn't due until 5 years after some indeterminate date in the first.
And so why didn't your client, at that point, first time they see that there's been an alteration in this 5-year deadline, why didn't they do something?
They
Like
did.
appeal?
Well, what they did, because they weren't included in the distribution of the letter. The letter went from NAED to DOE, the Department of Energy, and Sandia. It was not made public.
It was posted on the website.
Your Honor, it was not made public. It's
The
not.
website was publicly
Well,
accessible.
Citizen action, what I can tell you, members of this court, is that in order to obtain a copy of that letter, it required an information or a public records information request, which resulted in these folks obtaining a copy of the letter in late May of 2012.
You don't need an IPRA request to look at something on the website, do you? Can't you just go to the website and look at it?
I don't believe that constitutes adequate notice. It's clear that the department made no effort to circulate this May 2011 letter to the public, which is what we believe is required to provide adequate notice that perhaps you should appeal something. You shouldn't have to go searching the website to find the letter that you don't know anything about. But the important point I'm trying to make is that that letter did not approve an LTMMP, and by the way, that was subsequently withdrawn by Sandia a few months later, the 2007 one, so it was a non-issue.
So are you saying that you didn't have an obligation to do anything until there was an approval of the long-term plan?
Well, I'm saying that not doing anything is not the equivalent of not filing an appeal. I don't believe there was anything to appeal at that point because they had not approved a long-term monitoring and maintenance plan, which is now used after the fact as a constructive rationale for the delay as the triggering point for this 5-year period that will begin to run and eventually lead to a 5-year deadline for the report, which they now say is in 2019 because they approved this 2012 LTMMP in January of 2014.
So you're saying it was not a final administrative action that was appealable, is what you're saying?
We believe that the final administrative action that was appealable did not occur until January of last year, at which time the timely appeal was filed. This case involves a mix, obviously, of some tricky procedural, jurisdictional questions and this issue about an alleged ambiguity in the final order.
is up, Mr.
Is it up?
Yes, sir.
All right, thank you, Your Honor.
You have 10 minutes for rebuttal.
10 minutes. I believe, did I reserve 20 minutes and then 10 for closing?
You reserve 10 for rebuttal.
So do I have an additional 10 minutes now?
No, we have 10 minutes left, period. Not now, for rebuttal.
Have I already used 10?
You
20 minutes?
used 20, yes, sir.
Thank you, that was my question. Sorry. Thank you.
I'll ask you, Mr. Rexford,
Yes, Your Honor.
did Citizens Action complain at any time about the failure of your client to provide a 5-year report in 2010?
No, Your Honor, I'm aware of nothing in the record that indicates there was a complaint by Citizen Action to the Environment Department or to my client Sandia in 2010 or in 2011. Mr. McNeil referred to a transcript. There is a transcript in the record. It's from February of 2013. It is found at Record Proper 943 to 1025, and it is a hearing before the Albuquerque County Water Utility Authority, in which they are addressing the question of the LTMMP. As the court has alluded to, an issue in this appeal is the schedule for the first 5-year report that was required by the 2005 Environment Department to final order selecting a remedy for the mixed waste landfill. That opinion should be upheld for 2 independent reasons. First, the timing of the appeal is late. It's untimely because it seeks to challenge a department decision that was made in March of 2011. And second, the decision of the Environment Department on the schedules of the first 5-year report is a reasonable interpretation of its own permit provision. Although we are prepared to answer questions on either topic, I'll be focusing on the timeliness issue, and Mr. Grantham will be focusing on the reasonableness of that interpretation. I think
Why couldn't, Mr. Wexler, why couldn't the 5-year plan or report be done? Why couldn't it have been done? Why isn't it going to be done before 2019?
the answer to the first question, Your Honor, as to why couldn't it be done is that there's no additional information. It is true that there is very limited monitoring information on the groundwater underneath the mixed waste landfill, but the order itself requires an evaluation of the feasibility of excavation. It also includes an analysis of the effectiveness of the remedy, and that also requires the Sandia to do what's called a fate and transport model. I've inquired with the experts at Sandia and at the department, and I'm informed that doing a 5-year report without the LTMMP, the data that comes from the LTMMP, simply would not have any value whatsoever. And so it would have been there would have been 2 problems with that. First, it would have been a waste of resources for both the state and for Sandia. And second of all, it may have produced misleading information for the public, and so there simply was no value to doing that.
The long-term plan was in 2012. So why does it take until 2019?
Well, Your Honor, the LTMMP was submitted in 2012, but under the 2005 order, it was required to be approved by the department. That action occurred in January, and it was the opinion of the Environment Department that the information that comes from the LTMMP, the data that's necessary to update the fate and transport model and to evaluate the effectiveness of the remedy was necessary before a 5-year report could be done. And so that's why 5 years from now, that report will be submitted. My understanding is that the available information, monitoring data, is being evaluated, has been evaluated by both Sandia, the Department of Energy, and the department, and there is no imminent danger, so there's no problem in waiting until 2019.
It's the CMI report and plan, does that bear on the concerns or the dangers of contamination?
Well, I think, Your
I
Honor,
mean, is that, there were some, there was the interim CMI report plan, and then there was the long-term plan. And those plans and reports bear on the contamination concerns, such that it may not be as critical as citizens think it was to have a 5-year report earlier than 2019.
I think, Your Honor, that all of them bear on the contamination reports, and if I may, I think it's helpful to explain the difference between those reports. In 2005, the question before the Environment Department was, what's the final remedy? What do we need to do in order to prevent contamination? And they chose a vegetative cover with a bio-intrusive barrier. That final order required several steps that all came in a particular order. And you can see this in the permit modification that is at in the record at RP 1248 and a few pages thereafter. The first step in that process was the CMI plan, the Corrective Measures Implementation Plan. What that did was it set out from Sandia to the department exactly what was going to be done, how the remedy would be constructed, so that the department could say, yes, that seems appropriate. That was approved in, I believe, 2000 it was submitted in 2005 and approved in 2008. Then came the actual construction, the implementation of the remedy. That was completed in 2009. Following that came what's called a CMI report, and the purpose of that document was essentially to say, okay, we told you what we were going to do, we've constructed it now, and now let us detail exactly what we've done, so that the Environment Department had an opportunity to say, if there's any additional concerns, anything else that needs to be done, we're going to tell you what needs to be done. It was that 2011 CMI report approval in which the department said, okay, this is when you have to begin your 5-year reports. Then came the
How did
LTM.
that come to be included in that letter?
Actually, Your Honor, I think it was a request from Sandia to the department because it had been unclear both to the department and to Sandia exactly when the first 5-year report would be due. And so as part of that CMI report approval, Sandia inquired from the Environment Department, when is it necessary for us to do this? And the department responded as part of its CMI report approval.
And had this been this issue about when the 5-year report would be due, had that been a matter of continuing conversation between Sandia and the department, and so is that reflected in the record?
Your Honor, that is not reflected in the record. It is reflected in a document that was attached to the docketing statement, which is Exhibit 6 to their docketing statement. And you'll see there that in 2012, Citizen Action did an IFRA request in which they asked for information related to the 2011 decision, basically saying, what are you relying on for saying that the 5-year report is due after 5 years after the LTMMP? And you'll see as part of that Exhibit 6, there's an email train and minutes reflecting a meeting between the department and the Sandia.
Now I'm a little confused. If in 2011, and that was when, October 2011 when the letter came out.
Yes, sir.
So in 2011, a decision appears from the department in response to a request from Sandia for clarification. Why isn't the correspondence back and forth about that 5-year report and when it's due date? Why isn't that reflected in the record? One would think that this is a matter of continuing controversy between the department and Sandia. It would be reflected somewhere.
I think, Your Honor, that the reason that the department did not include that in the administrative record, and certainly that's a question that might be better directed to them since they control that record. But I think the answer to your question is that the approval of the 2011 CMI report is not the issue that's before the court. What is before the court is the approval of the LTMMP, which did not include occur until 2014. As we have argued in the briefs,
Now, where's the problem with that, with that assertion you just made, though? If in fact the CMI report doesn't deal with the LT, these acronyms just get with the LT, then how can you assert that one decision that's reflected in that letter is then right and had to be appealed at that point, otherwise it would be late?
well, I think that,
Because it seems to me that what you're saying is nothing really happens, that you have no responsibilities, Sandia has no responsibilities until it's LTMNP or whatever it's called, is approved. If you don't have any responsibilities, then why would citizens' action be forced to appeal at that time?
well, I think, Your Honor, the answer is because at that time in 2011 was when the decision on the timing of the first 5-year report was made. At that time, our obligation.
Who signed that letter? Was it a departmental decision, or was that a decision made by somebody lower level, or because for it to be final? Because what I can see, frankly, is if citizens' action had appealed in 2011, I can see the department and you asserting it's premature. This isn't a department decision. This is just one done. Nothing happens until we approve the LTMM. Then they can appeal everything. That's normally what happens in normal litigation. Lots of very important decisions get made in the course of litigation, which parties, it has huge effect potentially on how they run the litigation, but you can't appeal it unless you approve an interlocutory appeal. So how is this different from that?
So, Your Honor, I would first to answer your first question, it was signed by the acting bureau chief of the Hazardous Waste Bureau by the department. In a broader response to your question, I would.
Is that a departmental action that would be appealable?
Yes, it is, Your Honor.
And how do we know that?
Well, I think that the test that New Mexico courts have applied is, first of all, is the agency evaluation complete? And it was. We know that they have said this is when it must be done. That set the obligations of Sandia. And second, Sandia, the parties were impacted by that, and you'll see that reflected in the Mills case and others in the brief. I would strongly encourage the court to take a look at the two different decisions that we are talking about here. And the reason is, there really is no distinction as between the two. The LTMMP decision, the January 8, 2014 letter, is also a letter that is signed by the Environmental Health Division Director. It's at RP 1 and 2. It is a 2-page letter instructing that the LTMP has been approved. The approval of the 2011 CMI report, likewise, is a 2-page letter signed by the department. It can be found at RP 767, 768. And so what I would say to this is either both decisions are final, which is Sandia's position. In other words, the department determined in 2011 that this is when the LTMP was required, and that's what the way Sandia went forward. If that's the case, then the appeal is too late, because it should have been made in 2011, or at least by 2012 when they found out about it. Although I will certainly agree with Judge Fry that a large issue in the 2005 process was the documents that would be available to the public. Those were both put in the record proper, and that was required by the order, which you can see at RP 765, and also in a public repository.
Was the 5-year decision in the October 11 letter a subject conversation during the time that the department was deciding whether to approve the LTMMP?
No, Your Honor, not to my knowledge. That decision had already been made. And so the only references in the 272-page LTMMP to the schedule for the 5-year report referenced the 2011 letter. And to continue my thought on the two parallel letters, decisions of the department, if on the other hand the citizen action is correct that, that 2011 order wasn't final, well, the 2014 letter also is not final. There really is no distinction there. And then the appeal would be premature. And you might ask, well, then we would never get to hear that. Well, that's not exactly true, because as is set forth in the 2005 order, there is another permit modification that is necessary in order to deem corrective action complete on the mixed waste landfill, which will put the LTMMP provisions into the permit. That provision, that administrative proceeding is ongoing currently. I believe the comment period ends this coming March, and that is something that could be appealed. And so if both orders are premature and not final, then that is the time that they should be appealed.
That permitting process have anything to do with the 5-year plan issue?
I'm sorry, Your Honor.
You're talking about a permit modification process going on.
Yes.
Does that have anything to do with the 5-year plan modification?
It has to do with the LTMMP and the deeming of the full remedy complete, the corrective action which was required by the 2005 order will be deemed complete as part of that procedure. I see
It
that.
doesn't have anything to do with the question, the question before us.
Your Honor, I see my time is over. May I answer the question? I think that's correct, that it's not directly on the point of the 5-year report. It does have to do with the LTMMP.
I have one more question. How was the approval of the long-term plan distributed or made available to the public?
Your Honor, that decision, as I said, during the 2005 proceeding before the Environment Department, it was a point of emphasis of citizen action that the documents that were available be publicly available. On the 2011 report, which Your Honor is asking about,
I was
citizen
asking
action,
about the approval of the long-term plan.
which is the 2014 decision, that also was placed on the website and put in the public document.
Was it distributed differently
No,
than the October 2011?
Your Honor, no, not to my knowledge. Thank you.
Mr. Grant? I'm going to ask you the same question I asked Mr. Rexon, and that is, does the department's records anywhere reflect any complaint by Citizens Action to the failure of Sandia to file a 5-year report in 2010?
Your Honor, to the best of my knowledge, the time that that's reflected in the record is in the comments on approval of the long-term monitoring and maintenance plan, which is being appealed here. I think that really points to the procedural problem here. The appellant has characterized this case as involving tricky procedural issues, but those really all are raised by the fact that the appeal is not timely. And so the record for this case is the record for the department's approval of the long-term monitoring and maintenance plan.
So how did it come to be that the decision on the 5-year, the timing of the 5-year reports was included in that October 2011 letter? I mean, it didn't just drop out of the sky. There must have been something behind it that led to it, correct? So what's in the record that reflects the process that went on between the department and Sandia to come to that decision?
Well, that goes exactly to my point, Your Honor. There's nothing in this record for the approval of the long-term monitoring and maintenance plan for that decision, because that decision was made prior to 2011. Obviously, there had to be some back and forth between the department and Sandia, and
Why wouldn't those conversations be part of what it would be nice for us to see in deciding here whether or not, for example, that 2011 letter was final enough that the Citizens Action had to appeal in 2011, 2012?
well, Your Honor, again, the record that's on appeal here is the record for the approval of the LTMMP. And so...
So that's completely, from your standpoint, it's a completely different process from the process that led to the 2011 letter, which I take it approved the CMI?
That's correct, Your Honor.
Okay, so those are two completely different records in the department's mind.
That's correct.
Why?
Because
They seem continuous to me. It seems part of the same process.
they are part of the same process, Your Honor. And the final order set out a multi-stage process, as Mr. Wexler went over, with the submission, the corrective measures implementation plan, the corrective measures implementation report, the long-term monitoring and maintenance plan, and finally, the five-year report. So each of those is a separate decision. They're part of the overall corrective action process for the mixed waste landfill, but they are separate decisions. And as to whether
For the department's record keeping, does the department segregate them? Or is it all really one big file that you maintain?
I'm not sure of the exact administrative procedure that's used for the record keeping, but I think we do view them as separate separate records. And I think that is reflected on the website for each decision within the corrective action process for the mixed waste landfill.
After the briefing chief was filed, there was some motion activity dealing with completing the record proper for us. Did any of that motion activity implicate a need to include the records that dealt with the CMI approval or not? And if it did, should we have gotten that? I was under the impression that finally at some point we had a full record of what led to all of these decisions. What you're apparently telling me is that there's parts of the administrative record dealing with CMI which have not been produced to us. And I don't know whose fault that is. I don't know if that's your fault or if that's the appellant's fault for not following up. But it could be that for us to make an actual decision about whether or not the 2011 decision is final enough to require appeal at that point, that we need that record.
Well, Your Honor, the supplements to the record involved the fact that we, as Citizen Action pointed out in their brief in chief, the record, according to the website, included our response, our summary of citizen comments and our responses to them, but not the actual response, not the actual comments. So we supplemented with that. Citizen Action also pointed to this February 6th public meeting. The transcript was not in there. We agreed to supplement the record with that, as well as with the February 24th letter from the WPAB to the department and our response to that. We also
The February proceedings, were they in 2012 or 2013?
those were in February of 2013.
2013.
The October 11th letter was, seems to me, pretty significant interpretation of the original permit. Why would that call for more for public purposes? Why wouldn't that call for more than just publishing it on the website?
Well, Your Honor, because it is an interpretation. It is not a permanent modification.
It's a significant one in terms of time. It's a little hard to understand why all this took so long and why there's 9 years from 2010, more, that's necessary for all this process to take place. Seems long delays in between. How can one look at this without being concerned about that? Department's too busy? What's going on?
Well, it is a long process, Your Honor, but upon the approval of the CMR report in 2011, in October of 2011, the next step was the submission of the long-term monitoring and maintenance plan a few months later in March of 2012. I would point out that Citizen Action had earlier argued that an earlier publication of the long-term monitoring and maintenance plan would be premature until certain things had happened, until the final remedy was in place.
That was 2009,
That was 2007.
7, all right. So then you've got 2010, 2011, 2014, and now 2019.
Well, I would also point out, Your Honor, that the part of the delay between the 2012 proposal of the LTMNP and the 2014 approval of it was 5 months that were available for public comment. We had requests from Citizen Action and others for additional time for public comment. So we
On
have
the
to,
CMI report or on the long-term plan report?
on the long-term monitoring maintenance plan, we have to balance the the desire, the need to get things done and protect the environment with the procedural needs and the opportunity for public comment. And really that goes to the reasonableness of our interpretation. I mean, in order for the 5-year report to have any meaning, it needs to be informed by the data that's generated from the long-term monitoring and maintenance plan. I mean, from a public perception point of view, it would be easy for the department to say, do it now, this is taking too long. But we really, we need to let science drive the process. And the generation of the long-term of the 5-year report now, without any additional data, would not serve any purpose at this point. It would simply divert resources, both ours and Sandia's, from other efforts. Moreover, it wouldn't provide the public with any insurance because we know that it's not informed by the proper data. So in a nutshell, our position, as I stated, is that the purpose of the 5-year report is best served by being informed by the data generated by the long-term monitoring and maintenance plan. And that interpretation is reasonable because, well, for one thing, it's the most reasonable interpretation of the language of the order itself. As you observe, Judge Bustamante, there is ambiguity in the order. It does not specify a date certain for the commencement of the 5-year review period. However, there are textual and structural indications in the order that indicate that the proper time for the 5-year review is after the long-term monitoring and maintenance plan.
Now, that's the first 5 years. And then what about the second one, and the third one, and the fourth one? Those can be spread out 10, 15, 20 years. Or at least here, you've got several, you've got 14 years for 205. So we can go another 14 years after 2019, or what?
No, Your Honor, I would agree with the appellants on one point that every means every 5 years means every once the start point is determined.
But you're going to have, aren't you going to have interim reports? Are you going to have another CMI report, a plan report? You're going to have another long-term plan report? Those get delayed?
No, Your Honor, those were one-time.
One-timers?
One-time events.
And so what happens during the next 5 years after 2019?
Well, so the data will continue to be collected under the long-term monitoring and maintenance plan.
Without plans and reports, or
There,
official plans and reports?
there are no other major documents required by.
By regulation?
I'm sorry?
By regulation?
Or by regulation. So what the LTMA specifies is that data will be collected for the first 4 years, then it will take a year to generate that report. And then from then on, and that last year of the data collection will go towards the first year of the next 5 years, and from then on, it will be every 5 years. I think Mr. Wexler alluded to the fact that there is a corrective action complete determination hearing coming up for the next bill. That was alluded to in our brief.
What we have to end up doing is rely almost totally here on some kind of deference to science that we know nothing about, and it's not before us, basically.
Your Honor, I don't believe respectfully you have to rely entirely on deference to science. I think that bolsters our opinion, the fact that our scientists, it's their understanding that the relation between the data that's needed by the report and the data that's generated by the LTMP is such that it's best to implement the LTMP before the 5-year report. There's that.
But the problem is that none of that is reflected in the record we have. Assuming that you and Sandia talked about those things in your conversations back and forth, it's not in the record that we have. So even Mr. Wexler, when he said, I talked to my people, and they told me, they may be right, but it's not in the record. So we have no idea what they said or why or anything else. I look at the report and I say, I don't know why we couldn't have some useful information on transport marks. Transport, I assume, means how fast this stuff is moving. That doesn't have much to do with the ground cover, except to the extent the ground cover prevents it from accelerating, I assume. But the stuff is in the ground and it's moving, and the question is, how fast is it moving? Seems to me you don't need much information to have that, so you at least know where it's going and how fast it's going.
I see I'm about out of time now. Would you like me to?
Sure, you can respond to my ramble. See if you can find some useful information.
What we have now is data on groundwater. The implementation of the 5-year report, of the LTMP, will give us additional information on air, surface soil, data, so groundwater and biota, different parameters measured. So we have information on groundwater sufficient to say that this does not represent a substantial risk to human health and the environment. But we don't have anything that would further inform our determination of the effectiveness of the final remedy and feasibility of excavation. And again, Your Honor, in any case, whether regards to the finality of the 2007, 2011, 2011 and 2014 actions, the fact is that Citizen Action knew of this in 2012, and if they had brought the action then on that issue, then the record would have been different. The fact that this is not in the record for this appeal is because Citizen Action appealed the wrong action.
Suppose we were to decide that citizens didn't have to appeal that 2011 order at the time, the 2011 approval. And it's interesting that it's not approved by people you think would have to approve it to make it final, being the director or the secretary. Then where are we? Then where are we in this case? What do we have to decide in this case? Let's say the appeal is time.
Oh, if the appeal is timely, then you have to decide the merits of the department's interpretation of the 5-year review provision.
And how do we go about doing that? We have to read this entire record as supplemented, and nobody's referring to the supplemental stuff. Certainly brief chief and reply brief.
Well, Your Honor, I would just, I'm not out of time, I would just say that the reasons for the reasonableness of our interpretation, both the textual and the scientific basis, to the extent possible on this record, are laid out in our brief.
Great, thank you.
Thank you.
Mr. McNeil?
Thank you, Laura. We have a third person here, I guess we have two parties, so I'm up next. Let me first respond to, I believe, the question Mr. Monty asked about what did Citizen Action do back in 2012, challenging this failure to do the 5-year review. And I want to inform the court that they did object. There were a lot of problems that the CFR 270.41.42 et al. Detailed typical CFR regs that talk about public participation, notice, opportunity to be heard. Parties on the other side of this case have really neglected, ignored those requirements. But I want to say at this point, before I can do so, that what really has gone on here is that the department has transformed this, and it is a requirement in a sense in the final order, this requirement that there be a long-term maintenance and monitoring report. Now we call it LTMNP. But they've transferred that issue or that matter into a means of delaying the final, the 5-year report. And they essentially use that as a way to circumvent the every 5-year reporting requirement. There's nothing in the final order that lends credence to that theory. It's simply an improvised, after-the-fact rationalization to justify the delay that's occurred.
They justify it by what they consider to be a reasonable interpretation and a reasonable process.
Is your question, Judge Sutton, whether that was a reasonable process?
Reasonable interpretation and a reasonable process.
I don't believe it's a reasonable interpretation of the order, because the order doesn't come close to saying.
The order is ambiguous.
Is that your conclusion?
Yeah.
And the ambiguity, it seems to me in this case, is a result of the history of inaction. I don't find anything ambiguous about every 5 years. It does not beg the question, why don't we have a starting date for the 5 years in the order? No one questioned that at the time. The department didn't seem that to be that was an issue. It was not an issue. I don't know if it's an issue today.
It obviously became an issue at the 5-year time, at least with Sandy and the department.
Well, I believe that's a self-serving conclusion, Your Honor, that they advanced in justification for their own inaction. Every 5 years means every 5 years, and unless you put some qualifying language in there, except that the first 5-year report shall not be due upon until the commencement of X, that's not in the order.
Did the
Order.
5-year, did the lawsuit in 205 have any bearing on the delay?
The lawsuit, I believe, in 2005 was to challenge the selective remedy. Is that not correct?
Well, there was a lawsuit in 205 took 3 years.
And it didn't address, Your Honor, it didn't address the issue of when is the first 5-year report due, because it's clear on its face from the reading of the order, every 5 years means 5 years from now and thereafter. doesn't mean 2019, which is 14 years later.
The problem is that we're talking about this in a vacuum, because we don't have anything in the record which is presented to us that reflects the conversations between Sandia and the department about the 5 years. Now, I asked them why we don't have that. They say it's a different action. Shouldn't be part of this record. This record only deals with the LTMMP, doesn't deal with the CMI. I'm getting good at these acronyms, aren't I? And are they correct? Are they dealt with as different actions, so they have different records attached to them? If so, we have no basis upon which to judge your assertion that all of this is just an after-the-fact justification. It could be that they had some very serious conversations among themselves about this, and that the department actually paid a lot of attention to the question back when, in 2010 and 2011. We don't know. We don't have that record.
Well, you're correct, Your Honor, it's not in the record, and that's not our fault.
You're the appellant, Mr. McNeil. You're the appellant. It's your job to provide us the record that we need in order to make a decision in the case.
And we, Your Honor, we submitted, the record that was submitted by the department was woefully incomplete. It included summaries of some things.
Did you ask the department, did your motion include a request that they include the record having to do with the CMI back in 2011?
We did not. I don't believe that's relevant to the issue. As I said,
How can it not be relevant to the issue if that's the document in which they decided the issue you're arguing about?
but that's not, Your Honor, that's not the issue, the time that they decided this issue. That letter in October of 11, which required a lot of effort on his part to obtain a year later, did not approve an LTMMP. It approved a corrective measures implementation report, quite a different thing. Then it adds in this language about upon approval of the LTMMP, the 5 years will start tolling. There had been no approval in that letter announced of approving an LTMMP. That was later withdrawn. That's a
Completely
issue.
misunderstand.
With all due respect, I believe
Mr.
that.
McNeil, let me ask my question, okay? Am I completely misunderstanding the point of your appeal? I thought the point of your appeal was to complain about the 5-year reporting.
They did.
That the department is allowed Sandia to get away without providing at least 2 5-year reports to date, and that's just wrong. The decision about when those 5-year reports will be made by the department occurred in that October 2011 letter. Everything that dealt with their deciding that came before that. How can you say it's irrelevant, that all that back then is irrelevant to our decision about whether or not its interpretation is correct? I mean, you're not saying that you have a slam dunk case. Clearly it's not, and we've got a lot of questions here today.
Your Honor, I'm not suggesting that it's irrelevant. If I said that, that's not what I intended.
That's exactly what you said.
All right, well, I retract that statement. Maybe it's because I can't hear what you're saying. In any event, the decision in the March 2011 letter was for the purpose of approving a corrective measures implementation report. It was not to approve a long-term monitoring and maintenance report. There was such an LTMMP in place at the time, filed by Sandia in 07, subsequently withdrawn. The letter was about approving the CMI report, not about the long-term maintenance plan.
But it certainly was anticipating, Mr. McNeil, it had to be anticipating a long-term plan, which was next. Right? And they were approving a CMI report, a plan. Report after the plan. And I would assume they were looking toward the long-term plan, which was to follow. And presumably then, they were thinking about, I'm presuming, because we don't know, when the 5 years, since it's not now in 2011 or 2010, when the 5 years is going to be. So they would have obviously have been talking about that. We don't have that. We don't know. It would have been nice for us to understand that. And I think what Judge Bustamante is saying, that had citizens gone through the process of thinking through this, they may have specifically asked for all of those records as to how that interpretation and why that interpretation came about. Certainly we would like to.
You're talking about the interpretation in the October 11th,
Yes.
2011 letter.
Yes.
Another thing to consider in the context of that letter of 2011 is what it required to get it. It seems to me that a party has a duty to appeal if they choose to do so, shouldn't have to jump through hoops to find out that maybe something has happened that they should appeal. I believe that should bear on the court's consideration of the efficacy and adequacy of what they now contend as their justification. But my point is the two incidents of 2011 about which they didn't learn for another year and January of a year ago are quite distinct. We believe the latter is a final administrative decision that is appealable. The earlier was not. Now that's their argument. I understand that.
Your time's over, thank you.
Could I make?
No, sir, your time's done, thank you. For arguments, take the matter under advisement and opinion as soon as you can.